alleged that on December 2nd in a snowstorm that you were driving with a suspended license, and by the operation of that vehicle did cause the death of a young man named Anthony Miller. Second count, you were operating the vehicle without any insurance. We get lots of people doing both of those things, driving suspended and driving without insurance. When there's a death, it becomes a felony, punishable by up to 15 years in prison and a fine of up to $10,000. You are also charged as a fourth habitual offender, making it theoretically punishable by up to life imprisonment. You were arraigned on that charge, and bond was set by me in the amount of, I believe it was $75,000 cash or surety.
I think it was 100,000.
100,000. Yes, there it is, 100,000 right in front of me. I ordered that you not use any drugs or alcohol. I ordered that you possess no weapons or firearms, no assaultive behavior, wear a GPS monitor, and no driving. I also ordered that you must report to the day reporting center on the very next day and sign the condition to agree for testing. So you did. I believe you're on the GPS monitor now, and you signed that on December 3rd. You and I were, I think, over the Zoom feed. I appointed Attorney Ross Truckee to represent you, and there were records made at that time that I set the bond about some previous fails to appear, possible case out in California, a driving suspended ticket in Kalamazoo from November. So bond was set in the substantial amount of $100,000. Pre-exam conference was originally set for an earlier date. It's presently set for January 7th, which is my day. As I indicated, Mr. Truckee was counsel at that time. There was discussion that you were in discussion with the Levine and Levine law firm, the Marcoux law firm, and that you were going to be retaining Anastasi Marcoux, and he's here with you today. Sometime last week, I think this substitution was executed. It hadn't made it to the file at the time I dealt with this last week. There was a notice that we received on Monday, December 16th from the Day Reporting Center. It was Monday, December 16th was the date of the test. It was filed with the court on December 20. Well, it was filed with somebody, I guess us, on December 21st. December 21st was Saturday. So I don't know when we saw it. We first saw it on the 23rd. Ms. Davis saw it, and she moved to cancel your bond. She filed a written motion to cancel the bond, indicating that you should show cause why you should not be brought before the court for bond violation. The test.
The test was on the 16th.
16th.
The notice of the results was received on Thursday, the 19th.
All right, the one we had has a date of the 21st on it, which is a Saturday. You might have got it before we did.
That's, I think, when Pam from DRC emailed it to everybody was on Saturday. I had gotten it from them on Thursday prior to them filing that motion.
I think that's correct. The test printed result is from the 19th. However, the test is from the 16th. I don't know when either the prosecutor or the court received those results.
All right. Now, we had a very short notice emergency hearing on Friday afternoon or Monday the 23rd, the last day before the Christmas holiday.
Typically, it was on the 19th.
No, it was the 23rd. No, you're right. It was, let me look at my note here. It was on the 20th.
Yeah, that Friday.
Friday, not the Friday. I wasn't here Monday. It was Friday. It just felt like the last day because it was my last day. So we had an emergency.
This judge wastes zero time. He looks straight at the defendant and basically says, "This isn't just a case, this is a homicide." And just like that, the mood in the courtroom turns heavy. You can feel it. This isn't going to be a normal hearing.
Emergency hearing, show cause why bond should not be revoked. Notice was not given. They attempted to, but Mr. Thomas wasn't here. Mr. Marku wasn't here. And Mr. Truckee wasn't here, and neither was the public defender. I learned that a substitution was forthcoming, and Ms. Davis cited the court rule that allows the court to do a bond violation. I was not clear and still wasn't clear what my authority was to immediately revoke bond without any sort of hearing or due process. So I set the matter for hearing this morning. Ms. Davis represented at that earlier hearing that the laboratory reports have come back regarding the defendant's drug and alcohol tests at the time of the accident, and that they intended to be amending the charges. The petition to revoke the bond and the motion to cancel bond states that on 12/19, the prosecutor received the MSP lab report. Now, that would be for the actual driving, indicating the defendant at the time of the accident was positive for methamphetamine, fentanyl, and morphine, as well as amphetamines. They also allege that you have 3 previous operating while intoxicated convictions, and that on the 19th, the results were received back from the Day Reporting Center that you tested positive for methamphetamine and amphetamines on December 19th. Ms. Davis obviously was not very happy about that. Frankly, neither was I. And she asked me to revoke your bond. And is that still your request here, Ms. Davis?
Yes, Your Honor. Just to kind of clarify, bring the court up to speed too. We haven't amended yet because we're waiting for the computer crimes unit from MSP to give us the report on the telephone usage, which could end up resulting in an additional charge of reckless driving causing death. So at least the amendment now that we know will be happening is OWI causing death, which is a 15-year as a habitual fourth, and OWI third.
So here's where it gets worse. The defendant was allegedly driving with a suspended license during a snowstorm and someone died. What might have been a routine traffic violation suddenly turns into a 15-year felony. One bad decision, and everything changes forever.
Be a lesser included, depending on how that comes out, which is a 5-year, but also a habitual fourth. With the bond conditions that have been in place, it's my understanding from Attorney Marku that defendant has not been tested since the 16th. And so I guess part of our discussion prior to the hearing was, I'd like to have him test right now. And if it's a positive, then I would still be asking for his bond to be canceled. And if he passes it, I would leave it to the court's discretion as far as a punishment or some sort of repercussions for the use of illegal substances while on bond. Obviously not immune to the idea that, with recovery and relapse do happen, but this is a very serious situation. And Your Honor was obviously less concerned about the use because he wasn't driving, but we can't guarantee that he's not driving. We do have the GPS tether on him, which has been effective, and so we can kind of keep an eye on where he's going. But we really would like to get a handle on this substance issue. I also, in the emails with Pam from DRC, trying to get a handle on how they're doing the testing and what they're testing for. They are not testing for all of the substances that he was positive for at the time of the crash. So the test that they're using will not detect, I believe, fentanyl and maybe morphine. So they can do a 14-panel instant test. They typically only do the 5-panel, and then the alcohol test. I would ask that the court amend the bond conditions if he is going to remain out on bond, that he be required to do the 14-panel instant test and the alcohol test, and that it be on a regular instead of the random call-in, basically no less than 3 times a week, because these types of substances will typically remain in a system for.
And then comes the bombshell. Prosecutors reveal toxicology results: meth, fentanyl, morphine, all in a system at the time of the crash. This isn't just reckless anymore. Now the courtroom is staring at a much darker picture.